So the topic today, that is the polity topic, Article 136 and 142. So before we dive into what is these articles to talk about, first we'll see two relevant topics. The first one is, what does it mean by justice? So justice, the simple definition is, this is something, an act which can be performed by anyone. That can be an individual to another individual, society to an individual, court to an individual, or any other judicial body to an individual, or maybe government to an individual, or maybe parliament or state legislature to an individual, doing something or providing something what that individual is entitled to. So this, what this entitlement means here. The entitlement means rightfully something that should be belong to the individual should make that that particular thing should made available to the individual. So that can be done by a the family member, or maybe a relative, or maybe a society, or maybe a court, or maybe government. Can be anyone can make sure that given individual should be enjoying what he should be getting from the society or from the government. So suppose if you see from that point of view, the entitlement does not mean that protecting the individual in against to any injury or wrong committed by that individual. So what does it mean by that? Suppose if you see a scenario that suppose there are a couple of students. First we'll see what does it mean by entitlement. The entitlement means, suppose there are some two students and his teacher. Though the both of them have written an exam, the same question paper, and both of them written almost this the answers of same standard. And one student had a bad relation with the teacher, and another student do not have any kind of the opinion by the by the by the teacher on the given student. So the student, for the second student, the teacher has awarded the maximum marks, but for the first student who had a bad relation with the given teacher, the teacher awarded the less marks. So here this is something that a discrimination has been meted by the teacher to the first student. So this is something where the first student has met injustice. So suppose if the for this the first student also, regardless of what is the kind of relations to teacher is having with the given student, if she here the given teacher treats both the students equally based on the merit, okay, then you can see that justice has been met to the first student also. But in the if you see in another case here, the protecting again is the so-called here, the justice is not about protecting the individual against the injury or wrong. That injury and wrong is something that is inflicted or committed by the individual upon themselves. So because of it, there is an injury has been met, or maybe wrong has been committed by the individual. Suppose there is a scenario that before the examination, a student has met with an accident. Met with an accident because of his own reason, he met with an accident. So further, there, because of it, he could, he had become paralyzed for a couple of months. And because of it, he could not able to, he did not attend the exam. So in that case here, we cannot see that, the state or maybe government did not provide him an opportunity to write an exam, or did not provide the protection because he has, he has become injured, or maybe he has committed something wrong, that here the state or maybe society is not entitled, she is not have any obligation to provide any kind of facility for special provisions for the given individual to write the examination from his home. Okay, so this is something that the justice is not about protecting against something, the injuries or the wrong committed by the so-called individual upon themselves. And the extending the discussion here, that the justice is also is more about deciding what is right first. So first we need to decide what is right, what is wrong. Once you decide the right and wrong, then toward the right means here, that is justiciable. The given individual's demand is just and it is fair. Once it is decided the given individual's demand is right and fair, then the any person in the society or maybe government should provide extra benefits to the given individual who has suffered the given wrong. It is like something, if you see that the in the examination hall, many of the times we see there are physically disabled person. Physically disabled person means suppose there is a blind student. For the blind student here, the governments, by considering the genetic disorder which he is facing, the government do provide him an option to subscribe for a scribe, right? So, the providing an option for a scribe here is something that government is trying to create. The bridge are giving extra special treatment to that given student. That extra special treatment is what we call it as equitable treatment. Okay, it is not equal treatment, but equitable treatment, giving extra benefit to the student who is at a disadvantaged position. Okay, so this is the justice talks about. So to decide that, first we need to decide give this kind of preferential treatment. The first it should be decided the given wrong committed by the individual, the given wrong which is inflicted upon the given student or maybe an individual, whether that is right or wrong. Okay, the next thing is who will decide whether something for the given individual to get a justice, the given individual's demand, whether it is right or wrong, who will decide it? The first thing is to give the preferential treatment to the any individual in the society. Government do automatically do notice them and they do make policies through laws or maybe through different rules and regulation. So if not the government, then if an individual is specifically facing a problem, that individual problem is specific, and the government is not providing any kind of extra benefit to that specific individual, then the only resort available to that individual is approaching the judiciary. Then here judiciary is vested with the power to the deal with the providing justice to the individuals. But when it is deciding, the finally the justice is being provided by the judiciary. The different kind of preferential treatment that should be given to the given individual, how it has to be, how much of the preferential treatment that should be given, and on what basis they can they can decide what is the extra amount of the treatment or justice that should be provided to the individual. Here the courts generally do not have the general discretionary power to decide arbitrarily what is the extra benefit that should be provided to the individual who is facing an injustice. So there is always a law that might be passed by the parliament. So based in this law, everything has been mentioned that what are the specific beneficiaries, and to those beneficiaries what are the benefits that will be available in extra compared to others, other people in the society. Okay, so here that is the judiciary, when it is the meeting of the justice to the given individual, it will always go according to the law that is passed by the parliament. Okay, so that is what is here. The courts, the power is circumscribed by the law that is passed by the parliament. That means here courts do not have arbitrary power to decide or to give extra benefits to the any individual who is facing the injustice. And the another topic, associated topic, is what does it mean by complete justice? The complete justice means, generally, suppose if anybody approaches a court, the justice is all about justice is about something that is should be belong to the individual, what is rightfully belong to him. So it can be do with it can go with a dispute, a property dispute between two individuals. In that case here, the both people are individually going to the court and approaching the court. Court will finally decide who will be having the final authority or ownership of the given property. So this is something what is he is entitled to. Okay, so that is here the courts here, they specifically is deciding that what an individual should be getting in out of any dispute. So when the final judgment is being delivered by the given courts, what they the many of the times what we do always see is there is always one winner, one loser. So winner means he will be getting the winning the case, but loser who lost the case. Okay, and sometimes suppose if you see if there is a crime committed by an individual, so when the crime is committed by an individual against the another person, then the guilty is proven. For the guilty is proven means the person who has committed the crime, that person has been will be awarded with particular sentence. That means jail sentence. So jail sentence means here he has given the negative treatment. For the other person, it is about he is winning the case and he is getting some kind of remorse out of the judgment that the given culprit has been punished. So, but that is what is justice is all about. But the complete justice is even though there are two parties, or there may be in sometimes in a given case, there may be more than two parties. So whoever is involved in the given particular case, in the final judgment, the court can provide, the kind of judgment wherein it can be providing the justice to every party, those who are part of the given litigation. Okay, so that means here the complete justice goes beyond the justice. The justice is all about, the deciding the case towards one particular party, but complete justice is about taking care of the both, all the parties, those who are involved in the given particular case. So it is, that means here the court's role here is not about just deciding what is right and wrong. It is also about, when it is being decided wrong, even for the person who has committed wrong, that person also might have faces certain, suffered certain injustice. So even that injustice also need to be corrected by the judiciary. So that part of the justice is called as a complete justice. Complete justice means justice not only to the person, the party which is winning the case, and even the parties which are not, which has lost the case, even for those parties also, judiciary is providing these some kind of extra benefits. That is called, the making sure that justice is available. That is called as complete justice. So what are the different constitutional provisions that give power to the judiciary to go beyond the justice and to go into the domain of the complete justice? So if you see, there are, the two specific articles, Article 32 and 226. These are constitutional remedies available to the the citizens of the given country. That 32 talks about that, the writ petitions that can be issued by the Supreme Court, and the 226 talks about the writ petitions can be issued by the high courts. So these two can be used, by the judiciary in provision of the making sure there is a complete justice. The other two important articles that are mentioned in the Constitution, which are specifically available only to the Supreme Court, not to the any other court in India, that is Article 136 and Article 142. So this Article 132 and 142 here, these are not again ordinary rights. These are extra, the normal ordinary rights available to the individuals, but these are discretionary jurisdiction available only to the given high, Supreme Court. So the discretionary jurisdiction means whenever the given judiciary, that means Supreme Court, want, then only they can make use of these provisions 136 and 142. That means no individuals, no party which are fighting the case before the Supreme Court can go and ask, demand under Article 136 or under Article 142, provide justice to me. Whenever the judiciary wants to provide justice to the given parties which are under litigation, the judiciary think that they want to use these extraordinary provisions in the provision of the complete justice, then only at the choice of the given Supreme Court, these two articles are placed. Okay, so this is obviously to ensure that, to provide the rights and entitlements that should be made available to the persons, okay, in the society. Okay, so the first we'll see what is Article 136. Article 136 is specifically talks about the power available to the Supreme Court to grant a special leave. Special leave for what? They, to file an appeal against what? There are, the judgment that may be given by the lower courts like High Court, or maybe District Court, or maybe Sessions Court, which has given already certain, the verdict against, in a particular case. So in the given particular case, the party which has lost the case in the lower courts, so they have, they can approach the Supreme Court saying that here is a case that, I have lost my case, but I can see that, there is the gross injustice has been met to me by the court when it is, by the lower courts when they are deciding the given case. Please give me leave. Leave means permission. Leave means permission to file an appeal against the lower court's verdict. So here it is something that, you need to take first leave. That means unless the given Supreme Court give permission to file an appeal against the lower court judgment, the given party cannot file, file a case against the lower court judgment in the Supreme Court. So that, here is that something that the only with the permission of the Supreme Court, the given party can file an appeal. against the lower court verdict in the Supreme Court. So this is it an automatic right? No, as we discussed previously, 136 and 142, these are not automatic rights available to all the all the parties which are losing the cases in the lower courts. Only whenever with the permission of the Supreme Court, or maybe at the discretion of the Supreme Court, the court can allow to file an appeal in the Supreme Court against any of the judgments passed by the lower courts. And when we see what is exactly the scope of Article 136 in the words of the Supreme Court itself, in one of the case, it had mentioned about. So here also it has specifically talked about that Article 136 was never meant to be an ordinary forum or ordinary. The ordinarily the given individuals do not have the power to file an appeal against all the the cases that are the judgment that are delivered in the lower courts. So these are two sections you can see, section 96 and section 100 of the Civil Procedure Code. So here under Civil Procedure Code, any judgment has been delivered by the lower courts, the like sessions court or the district courts. In this code, these two sections specifically talks about the power available to the party whichever has lost the given case. They can automatically file an appeal in the high courts. So here the automatic right or ordinary right is available to the individuals to file an appeal against the lower court judgments in the high courts. But whether that kind of the same ordinary facility is available with the Supreme Court? No. So that is what here Article 136 is talking about. Any appeal to file in the Supreme Court, you need to take first permission from the Supreme Court. But that's not the case with respect to high courts. Okay. So any judgment delivered by the district court and maybe the sessions court, automatically under 96, section 96 and section 100, automatic and ordinary right is available to the both the parties to file an appeal in the higher court called as high court. But that same kind of ordinary is not available with the the individuals to file case before an appeal before the Supreme Court. So here under constitutional scheme, the ordinary last right in the country, in the ordinary cases was meant to be high court. That means for ordinary cases, the last court of appeal is only high court. Okay, so beyond high court, it is not the given individuals or citizens do not have the ordinary right. Only they have only they can file the appeal in the Supreme Court with the permission of the Supreme Court. So here is you can see the Supreme Court as an apex court. Apex court means top court in the country, was meant to deal with important issues only, not with every ordinary case. What are those important issues? These are like constitutional questions. That means in a given particular case, there is something that constitutional interpretation is necessary. So there you need higher judicial, the members like the judges occupied in the Supreme Court. And if there is any question of the general importance to the larger society of India, larger society, so in that particular that particular question that needs to be needs to be settled, which have the that answer will have the larger implications in the society. Those specific in any case these questions are involved, those cases can be accepted in the Supreme Court. And suppose in any of the the case the judgment that are delivered already, in those judgment, if Supreme Court feel that a grave injustice has been met to the party whichever has lost the given case, then in those cases that Supreme Court can accept can give the permission to the litigant to file an appeal before the Supreme Court. Okay, so this is the scope of Article 136. So this is not an ordinary right, but this is something, a right that is available, with only with the permission of the Supreme Court. Individuals can access or can get benefited for the, to get the complete justice. The another article, associated article, is Article 142. Article 142 summarizes that it is the called as the enforcement of decrees and orders of the Supreme Court and orders as to discovery, something extra. But specifically what this Article 142 talks about. Under Article 142, there are two sub-provisions. The two sub-provisions, the first one, Article 142.1, it specifically talks about, it the Supreme Court can exercise its jurisdiction wherever it is necessary, if it wants to provide the complete justice in any of the cause or matter pending before it, or maybe anything that may be passed here, whatever the complete, under the complete justice, the given Supreme Court have the power to exercise its jurisdiction, right? So wherein it can pass certain decrees or orders which have the implications or powers which can be enforceable throughout the territory of India, throughout the territory of India, and how they will be applied or may be automatically enforceable in throughout the India. It may be the procedure may be mentioned in any of the law made by the Parliament, or maybe if there is no law mentioned already, then the Supreme Court, it's Supreme Court, itself can decide that what is the procedure also. Okay, so here it is something that extraordinary provision, available with the Supreme Court to provide the complete justice to the parties which are under litigation. Okay, so this is about the Article 142.1. The second provision in Article 142, it talks about that something wherein Supreme Court can demand for the effective, the settlement or the looking into the given particular case, the Supreme Court can ask for the attendance of any particular person, right, which will be helping the Supreme Court or the Supreme Court in deciding the particular case, right? Or maybe any, the production or discovery of any documents. Again, these will also help the Supreme Court in deciding the particular case, right? Or any of the investigation, right? So here the Supreme Court can, the demand, order for investigation, thorough investigation of the given case, right? Or maybe sometimes in anybody, any individual, or maybe government or government functionary, if they violated any of the previous, court judgments, then you can call it as a contempt. So if anybody if anybody violated the previous Supreme Court judgments, then the Supreme Court under Article 142, subprovision 2, it can also decide what is the punishment for that violation. Okay, so here is that for a particular, for specific settlement of the, for effective settlement of the given particular case, here court can ask the help, ask any person in the society come and attend before it in person, or provide, provide any documents. Okay, it can demand from any individual or maybe from the any government department, or maybe it can ask for the investigation, thorough investigation for the greater details, to know greater details about the given particular case, or it can also, decide the punishments for the people who have violated the previous judgments of the Supreme Court. Okay, so here the, regarding the second provision, more than the second provision, here the first subclause, the 142.1, it is having the the now and then is being resorted by the Supreme Court in the name of providing the complete justice to the individual. So complete justice here, first we'll see what is the scope of Article 142 as mentioned by the Supreme Court in various judgments. So in multiple judgments, Supreme Court has referred to what is the scope of Article 142. Article 142 as such, it is have, it is have giving the sweeping powers to the Supreme Court, saying that, this particular article is at the discretion of the Supreme Court. It can do, provide anything as part of the given judgment in the name of providing the complete judge, the complete justice. So the three specific examples I mentioned, I took here. The first one is Union Carbide case. Union Carbide was a company which was actually a chemical company located in the Bhopal. There was an accident because of the poisonous nerve gas that is released out of the given company. Almost 300 people had died in the Bhopal region in 1984. This was a case, that is the particular tragedy happened in 1984. The Union Carbide case, it is a US based company, okay, which is actually manufacturing the chemicals, fertilizers in India. So here with respect to when the court, when it is deciding the punishment, whether the Union Carbide has what is the crime committed by this particular company. So in this, in this particular case here, apart from the delivering the judgment that who is wrong and who is right here, the court went ahead and even mentioned that what is the compensation amount that should be paid by this particular company. So generally, this kind of, the particular amount of compensation that should be paid by the affected parties, or maybe the parties whichever is lost the given case, right? It has to be go with the law that is specifically passed by the parliament. But here is a case that the union, the parliament did not pass any law specifically mentioning what is the compensation that should be paid by this particular company towards the negligence. Because of the negligence, the given accident happened in the 1984. So here the court, by resorting to the extraordinary provision of Article 142, it has decided even the compensation amount also, which is something extraordinary. Generally, the judiciaries do not go and outrightly announce the compensation amount if there is no law specifically passed by the parliament. So this is something, an extraordinary provision used. And another thing here, they also talked about the scope of Article 142 as such. Here, when they're talking about, commenting on the scope of Article 142, they talked about, suppose here in any of the law passed, suppose take an example, in any of the law, the parliament passed, says that, the compensation for a particular, suppose if there is a disaster, like natural disaster, like floods. During floods, if there is, if any of the person had died, so to those people, the ex gratia or compensation to the victim's family can only be announced by the government. Okay, if that specific provision is mentioned in any of the law. So that is a specific law passed by the parliament. But that means here under that law, you are limiting the powers of the judiciary not to announce any compensation towards the people affected during the floods. Okay, so but the given, suppose if anybody filed a case before the Supreme Court saying that here we are affected parties, but we are not getting rightful justice, right, equitable justice from the government. So we are please come to our rescue in providing the justice to us. If that is, the court, the case reached to the Supreme Court, and Supreme Court finally decide when it is deciding, support if it wants to give, announce the compensation. Okay, so here is that the law specifically talking about Supreme Court cannot do that, only government can do that. Whether government can impose certain kind of restrictions on the judiciary to announce the compensation here. So this is where here they talked about, through ordinary law, if you are imposing any of the restrictions on the scope of the Supreme Court when it is to deliver the justice, right? Here it comes in contravention to the constitutional provision of Article 142, which gives extraordinary powers or constitutional the provision powers to the Supreme Court to go to the any extent in providing the complete justice to the individual. So here is where the law is coming, the specific law is coming in contravention to the constitutional provision of Article 142. So an ordinary law passed by the parliament and a constitutional provision mentioned in the constitution, when it comes to this versus this, always constitutional, the provision will be winning over the ordinary law. So that means no government agency can put restrictions on the powers of the Supreme Court if they want to deliver the complete justice. So that is the summary of this particular judgment, what is commented by the Supreme Court. And the second famous case where the Supreme Court has been resorted to the extraordinary provision is recent case, that Ayodhya verdict. So Ayodhya verdict, as we know, in 1990, that the Kar Sevaks has demolished the Babri Masjid. It is because they consider it as the birthplace of the god Rama. So here, that is why the Babri Masjid has been demolished. After that, the given case is about before the Supreme Court is about who is owning the given land. Where there was a Babri Masjid previously, now it stand demolished. Who owns that particular land? Whether really that is the real birthplace of Rama or not. So when the court is finally delivering the judgment in 2019, it has been decided, yes, that is the birthplace of Rama, and it should be rightfully belong that place to the Hindu people, right? So that they can let them construct the temple. So when it is here in the specific case, the other litigants, that is the Muslim community people, they lost the case here. But the Hindu community has won the case. It is like, it is looking like this, right? But there are other parties also, the other litigants also, who joined in this particular case, wherein there are more than two parties which are under litigation here for the ownership or the management of the given land. Okay, so when the final verdict is delivered, finally the verdict delivered is here. It is looking like the Muslim people has lost the case. But here is a case. The article by using extraordinary article 142, what the Supreme Court did here is the by giving the ownership of land, the space, the specific place to the Hindu community. Again, here, even for the the parties, the Muslim parties which has lost the case, even for these people also, the Supreme Court has the try to do some justice. So the justice here is Supreme Court has provided the 5 acres of land. It has asked the Uttar Pradesh government to provide the 5 acres of land to the Muslim communities in nearby to the Ayodhya, okay, wherein they can reconstruct their own, the religious place, their own religious place. So provision of this land should be free of cost, and so that these, the affected parties here, the Babri Masjid has been demolished. So demolished means here, this is a wrong committed by some people in the society. So this to ensure that there is a remedy for the wrong committed by some people in the society. The Supreme Court has provided the 5 acres of land to the Muslim parties so that they can, in the near vicinity of Ayodhya only, so that they can construct their own religious place called a mosque. So this is an extraordinary provision, and even the party which has lost the case, even to that party also, the Supreme Court has done something extraordinary. Okay, so this is called as complete justice, taking care of every party. You can see that there is another third litigant who is also part of this particular, the litigation, that is called Nirmohi Akara. So this is a particular sect in the Hinduism, right? They do have different, the religious practices, but they are also, demanding that, we have particular, the rightful stake in the given place towards the Ram and the god Rama. So here in this particular case, again, by using Article 142, the given on the given particular piece of land where they're going to be a temple that is going to be constructed, Supreme Court has clearly asked here the Ram Janmabhoomi, the community to whom the land ownership has been assigned by the Supreme Court in this judgment, that this particular community have historical presence in the given particular site, right? So given their role, the a particular appropriate, in the given manner, going to be the temple that is going to be constructed in the management of that particular temple tomorrow, there should be an appropriate role should be assigned even this particular sect also. Even to this particular sect also, some kind of role should be assigned in the management of the given temple trust that is going to be, the built tomorrow. Okay, so here even, that means this actually this particular, the sect was demanding that, that land belongs to us, but the land rights were not given to this community, this particular sect. But the thing is here, Supreme Court has made available another provision of providing a space in the management of the given temple trust that is going to be built tomorrow. Okay, so here all the parties has got benefited. So for every party, those who are involved in the Ayodhya case, here Supreme Court had done, the justice. Okay, so this is called as a complete justice means. So that means in the given particular case, nobody is a winner, nobody is a loser, everybody is a winner. And the another third famous case is the recent case, that is the case of Perarivalan. The case of Perarivalan is, first we'll see the sequence of events that are happened before. So Perarivalan, he was a person that at the age, when he was at the age of 19, he actually supplied the batteries, right? The batteries which are used in preparation of the belt bomb, which has been used by the assassination LTTE sympathizers to assassinate the then Prime Minister, the ex-Prime Minister of India, that is Rajiv Gandhi. So in that case, obviously here, as he has provided the batteries, here he was also committed the crime, and for that crime, the Supreme Court has awarded the death penalty. So, but before before he hanged, that Perarivalan has actually filed a mercy petition. The mercy petition means that, proving his innocence, that, I did a mistake because, at the younger age, right? So here, give me a second chance to live a normal life. right? A respectable life in the society. So he has filed a mercy petition with the Tamil Nadu governor in 2015. Okay, so he is in jail from the almost 1992, because that is the time in 1994. So here the the mercy petition that is filed before governor, it is under Article 161. Article 161 talks about the powers available with the governor of the given state. Okay, powers available with the governor of the given state to grant pardon or remission or remit or commute the sentence of any person convicted of any offense. It can be of any offense, doesn't matter. But the governor of the given state under Article 161 have the power to decide the mercy petitions has been received by the governor office. Okay, so under this provision, the given the particular person has filed a mercy petition. But here, the governor did not take any action. Here, the governor means, again, the decision needs to be taken by the state cabinet. Governor do not have any independent, discretionary power here to decide the mercy petition. This file should be forwarded to the state home ministry, and home ministry will be discussing with the government and with the cabinet, state cabinet, and state cabinet will give the recommendation. Based on those recommendations, actually governor should be acting upon. Okay. So here is a case you can see in 2018, finally, the state cabinet have taken a decision. The decision is that they want to give the mercy to the given particular convict, the Ferrari Wallen, that they requested the Tamil Nadu governor that release all the convicts. See, along with him, there are other 6 persons, those are involved in the given particular crime, and to whom that the death penalty has been awarded. So to all those 7 convicts, the Tamil Nadu cabinet has recommended to the governor that please release them, give them the mercy. So release them means finally he has to sign the given document. That's it. The decision has been taken away by the cabinet, but finally the final decision has to be come out from the head of the given state, that is from the governor. But governor here, rather than the signing the given piece of paper, that is signing the given giving accent to the decision taken by the Tamil Nadu cabinet, he did not acted anything. He was just simply sitting idle without taking any decision. So the Ferrari Wallen has filed a case in the Madras High Court, saying that here even after the recommendation of the state cabinet, governor is not deciding anything. He is continuously sitting on it, but actually governor do not have any discretionary power to sit on it. He simply has to act upon the aid and advice of the state cabinet, right? So here, even the Madras High Court also got angry, and even the asked the governor office that take a decision on the given mercy petition as soon as possible. And the time limit for the deciding of the mercy petition, anyway, obviously it is not mentioned in the constitution, but not mentioned in the constitution does not mean that he can take any time. The governor office do not have the liberty to take any amount of time to decide any particular mercy, the decision on the mercy petition. So here it is because the constitution makers believed in the faith and trust attached to the constitutional post, because governor the post is a constitutional post. So constitutional post means these the people occupying the highest position should be always acting in the faith and trust of the people, right, or to the constitution. So that is why they did not mention in which what is the time limit by which the governor should decide the given mercy petition. Okay, so that's why it is advised the governor office to take the decision as soon as possible on the given mercy petition, the decision which has been already passed on by the state cabinet. But even then also governor did not react. So in January 2021, the Ferrari Wallen filed an appeal in the Supreme Court, and Supreme Court here is clearly warned again the governor office, saying that if you are not taking any decision, we may have to intervene. Okay, so this without any reason delaying the specific taking the decision on the specific particular case is not permitted actually by the constitution. Okay, so in what happened is immediately after the Supreme Court pronouncement in February 2021 last year, governor office forwarded that the mercy petition, the state cabinet recommendation of releasing all 7 convicts. Rather than signing it, he forwarded the mercy petition to the the President of India. So saying that the any of the crimes committed against the any of the central laws, the mercy petition can only be decided by the central government. That is the argument. Under that argument, the governor office has forwarded that the mercy petition to the governor, the president of India. So when when it's sent to the president office, even president also did not take any decision immediately. So even then, so since 2021 till recently, it was continuously, it was there in the president office, but even president also did not take any action. So president means again here, this particular mercy petition appeal should be forwarded to the central home ministry to decide by consulting with the central government cabinet. It has to give its recommendation. That means here, government did not make any recommendations in towards the whether what kind of whether the mercy petition is rejected or accepted. Okay, so finally here this the case again reached to the Supreme Court, saying that again the government is not taking any action, but here my right, that is article 21, the right to life, is being clearly violated by not taking the on the the speedy decision on the given particular case. Okay, so here the court, what it had done here is, the Supreme Court, the clearly remarked that if from going ahead, article deciding the cases under deciding the mercy petitions under article 161, the powers available with the governor, those will be subjected to judicial review. That means if there is any delay, then Supreme Court can clearly ask the reasons. What are the reasons for the delay in taking a decision? Generally in this till now, the under article the mercy petitions or pardon powers available with the discretionary powers available with Supreme Court, or maybe with the the governor, or maybe with the president, those were never questioned in the court of law. It is because the respect that is attached to the highest constitutional authorities in the country, that is president, in the state, that is governor. So the governors, the president office works, or maybe the governor office related works, can never be questioned in the judiciary. So that means on those the specific powers assigned to these constitutional powers, there was no judicial review available previously. But now the Supreme Court has clearly mentioned that the under article 161, the discretionary powers available with the governor to decide the mercy petitions will be coming under the judicial review. Okay, so and another thing is here, the center, what it is, central government as one of the party in the in this particular litigation before the Supreme Court. The central government argument is the the power to grant any remission on the any cases filed under section 302. The section 302 of IPC talks about the murder. So on these crimes, to give the the mercy, or maybe to give any remission on the death penalties, the power lies exclusively only with the president. That power does not lies with the governors of the given state. So the Supreme Court argument here is, if that power is exclusively available with the president, then why article 161 at all mentioned in the constitution? That was a report question asked by the Supreme Court to the central government. So here, that is why what the Supreme Court has clearly rejected this argument, saying that only the president has the exclusive power to grant the remission. Okay, and here in this particular case, looking into these merits, what happened till now, that this particular individual has served more than 30 years in the jail sentence, and rather than the hanging him to the death penalty, he has been continuously in jail, and mercy petitions is not, the decisions has not been immediately announced by the state government, governor, or maybe the president. So because of it, you can see last 30 years every day he was living between the the horror of when he is going to die. So this is something, the violative of article 21, which talks about the right to life. Right to life is also about a confidence that he will be living on. So some any individual state or state agencies cannot make any individual to suffer these kind of injustices, that is hanging between the death and the life, wherein this question every day he is living with this question that whether that my mercy petition is going to be rejected or accepted. So the not taking the decision, every day he is living with that fear. So that is also tantamount to torture. So state or maybe state authorities do not have any right to torture the individuals or citizens of the given country. So that is why because the last 30 years of the injustice he has met, that is that article, right to life, article 21 did not met to the given individual. So because of this grave injustice, now we are using extraordinary power, article 120 and 142. We are immediately releasing that individual called a Perarivalan from the given particular case. So all the cases which are pending against him will be stand cancelled. Okay, so this is where again here, by using extraordinary provision of article 142, the Supreme Court, without again asking the president or maybe governor to decide the case faster, right? It itself has decided the case. So what should be decided by the governor or maybe president here? So that means here the president do not have any power on the Perarivalan case. So that means what should be the rightfully doing by the governor? That role has been done by the Supreme Court by taking over resorting to the extraordinary provision of Article 142. So this is something called in the provision of the complete justice to the individuals. Sometimes they can resort to the extraordinary powers. Extraordinary powers means now they performed what governor should be doing. That power is also performed by the Supreme Court. So this is something, this is here the scope of Article 142 and the specific case of Perarivalan, and the specific case why the Supreme Court is used the extraordinary provision Article 142. Okay, this is the end of the topic.